But if you were representing him, Christa, would you think he might want to take the stand again?
Based on the evidence that I heard come in, I think that there was a lot of inconsistencies on what led up to the fight and how he initially presented himself. So I think that the decision to not have him testify was a very sound one.
Yeah, now, Joseph, let me get to you and ask you the same question. And I agree with Christa. I think there were a number of inconsistencies there. But in a case of self-defense, it's an affirmative defense, and you might think that the jury might want to hear from him directly.
Yes, maybe. But listen, you got to remember the burden of proof is on the state. They're going to prove beyond a reasonable doubt, okay, that this defendant committed these crimes. Listen, 99% of the time, defendants never do themselves any good by getting on the stand. I don't care how eloquent, how smart they are. They usually get themselves into trouble. He's already boxed himself in with some testimony from the pretrial hearing on the stand your ground portion of the case, which are facts that are pretty much stipulated to. Anything beyond that in cross-examination from the state could sway this jury, totally against him. So by him staying off the stand is a smart move. I agree with my colleague. A lot of inconsistent statements, definitely going to raise doubt. Has a good shot to maybe beat this case. Worst case, definitely a lesser charge.
As I watched this case, there were a couple of areas where I thought the defense might have beefed up their case a little bit. One of them was this idea of blackouts. He said he blacked out that day. He hit him, the victim in this case, a couple of times. Then he blacked out, couldn't remember what happened. There was lots of testimony, and the prosecution focused on this, and I think I'm clear as to why, but they focused on the fact that he had a history of this. It happened a number of times. I think he mentioned in one of his interviews 4 or 5 times before that when he would get into these altercations, he would black out. And I thought there was an opportunity there for the defense, Christa, to maybe dig on that a little bit, dig deeper into that, and give not only in terms of sort of mitigation in this case, but maybe even as a defense.
Yeah, I was really intrigued by that, actually. I think that in order to do that effectively, however, he would have had to probably have a medical expert testify about it. It would probably have to be something that existed within medical records, or alternatively, he could have done it through his brother who took the stand, his ex-girlfriend who took the stand. And it wasn't really explored very thoroughly. I think that what the prosecution did on the flip side with that issue was really made it out to be more like an excuse rather than a real thing. So I think that the defense hurt themselves a little bit there by not really pressing that defense to make it come to light and make it seem a little bit more reasonable.
Joseph, and then when I sort of take that analysis to another level, that blackout might have vitiated the intent to harm to the point where he killed Raul Ortiz. But none of these charges really involve the intent to kill. The intent has to be A, for the burglary, and B, just to inflict an assault, because then he's convicted and facing life in prison.
Yeah, that's right. You got to walk yourself into these other crimes. I mean, the blackout, it wasn't a defense, but the blackout justification helped him out when he gave his testimony in the stand your ground hearing. It eliminated his ability to really recant other facts on cross-examination and allow the state to really kind of get him to admit other issues that would have been detrimental to his case. As you roll it into the trial itself, is there an issue of mitigation? Is there an issue of possibly him not having the mens rea to commit these crimes? I think it's very tenuous. And again, I constantly agreeing with obviously my colleague. There's not a lot of medical support to further that defense.
Yeah, and Christa, finally, we get the lesser included here. And I always thought this case felt a little bit more like a manslaughter case. Is there a possibility here that, there's a technicality about going over the line or not for the burglary charge. Can we see a manslaughter conviction here?
I think that's the most likely conviction. I think that this was an overcharged crime. Felony murder is it's mutual combat. Did he go there with the intent to cross that property line and then commit a felony on the other side of it? I don't think so.
I'm sorry, I got to cut you off because I'm coming to the top of the hour. We got to get out. I want to thank you very much for standing by. Sorry we didn't get to talk more. Joseph Barone, you're sticking around for the next hour, so I appreciate that. Right now, we're going to take a break. We'll have much, much more on the other side. Stay with us.